Ready, start. Feeling aggrieved, the respondent number 1, instead of appearing before the disciplinary authority, had preferred an appeal before the division bench of the High Court. In appeal, the division bench did not say that after acquittal in the criminal case, departmental proceeding authority, but it was held by the division bench that whether the delinquent had asked for the copies of the documents relied on by enquiry officers as well as by the disciplinary authority was not at all material. According to the division bench, unless a document is included in the list of documents annexed to the charge sheet, the same cannot be used without giving sufficient opportunity to the delinquent and without obtaining leave for relying on the same. As this was not followed, according to the division bench, the disciplinary authority itself was liable to be quashed. At this juncture, we may remind ourselves that the learned single judge had also held not reliance could be placed on the documents not supplied to the respondent number 1 unless such documents were supplied and sufficient opportunity was given to the respondent number 1 for filing representation and comments against such documents. It is for this reason that the learned single judge directed the disciplinary authority to supply copies of the documents to the respondent number 1, allow respondent number 1 to file his comments, and then reach a fresh and final conclusion on the issue referred to herein earlier, after giving respondent number 1 a fair hearing. It was further held by the division bench but that since the district magistrate was not examined and no one had proved the reliability and authenticity to his report, it was not open to the enquiry officer or to the disciplinary authority to rely on the said report of the district magistrate on the basis of which a finding was arrived at by the disciplinary authority. The division bench was also drawn an adverse interference by holding that the enquiry officer had exceeded his jurisdiction by relying on the depositions of witnesses alleged to have been examined and relied on by the district magistrate without examining such witnesses in making his report. Accordingly, the division bench held that reliance on such depositions was wholly illegal and void, leading to perversity. Thereafter, the division bench also had taken into consideration the fact of non mentioning of rash and negligent driving of respondent number 1 in the FIR's information report. Going into the facts and circumstances of the case leading to the filing of a FIR, the division bench held that since the FIR did not mention about the rash and negligent driving, no reliance could be placed. It was also finding of the division bench that since only a Xerox copy of the district magistrate's report was filed before the enquiry officer, such Xerox copy of the report of the district magistrate was inadmissible in evidence.